John Stahl is a professional land surveyor in the states of Utah and Montana, currently owning and operating Cornerstone Land Consulting, Inc. in Salt Lake City. Mr. Stahl specializes in surveying land boundaries, resolving boundary conflicts, performing title and historical research, land boundary consultation services, mediation, and dispute resolution. He is qualified as an expert witness in numerous boundary cases, excess and negligent cases. He has furthered his mediation education by participating in a state qualified training program. He has also completed a training program to earn recognition as a certified federal surveyor. Mr. Stahl has served as his profession as the state chairman of the Utah Council Land Surveyors and the Utah delegate to the Western Federation of Professional Surveyors. He's an adjunct professor at Salt Lake Community College and the Utah Valley University, and he also teaches comprehensive land boundary law courses such as tonight. Mr. Stahl has also authored numerous articles and publications covering topics on boundary laws, research and resolving conflict of evidence. Good Lord, which is what we're talking about tonight. So I appreciate your time as well as always, as any presenter comes on here. But I know you just got done doing part of this presentation in Texas, and so we definitely appreciate you kind of following up and having a nice conversation with us as well tonight, and then again part two on in a couple weeks. So I will turn it over to you, and those can jump in and save down his PDF file off the Dropbox I put in the. Thank you, John.
All right. Well, thanks, Trent. Your timing was impeccable with getting this thing pulled together. The presentation that I just gave a week ago now in Texas. This is the same presentation that I gave there. And I've given this presentation in a number of different states around the country, just doing invitational speaking at surveying conferences around the most of the country so far. I've hit more than half of the states so far. But I really appreciate the invitation, and I feel myself blessed to be part of the esteemed few that have been able to make a presentation on your mentoring Mondays. It's been an incredible outreach program. It's can't get any better than this.
Thank you.
Yeah, that's my specialty is fixing boundary problems for people. And when I started my company back in 1988, I recognized a real problem in our profession, in that we were all taught pretty much to really very well on how to do surveys, how to determine boundaries, and to how to document problems and discover problems and how to document those problems. And but then it all kind of falls apart at the end of the game there, because we were told to just hand a pocket full of problems to the client and walk away, take our check and go find another problem to document, and let the attorneys fix it. It doesn't take very long when you're involved with these boundary issues and boundary disputes to really figure out that there aren't many attorneys out there that, one, know how to fix it if they did, if they wanted to, but usually no, the only thing they want to know is the name and address of your neighbor so they can file a lawsuit against them like they did this to you, and they're stealing part of your land or something. When you really start looking at the legal arena and what the courts are expecting from our profession, it starts to paint an entirely different picture than what at least I, and I'm sure many of us were taught. And unfortunately, it takes us quite a while in our career path before we really start realizing it and wondering what else can we do here. And so I've spent the last 30 years trying to figure out what else can we do and then how to do it. So I'd like to share some of those discoveries and some of those epiphany moments that I've had in my career in figuring out and making sense out of the entire survey process from beginning to end. So with that introduction, I'll get going here with this idea. Now, in the materials that I presented that you can download, There's about 110 pages of or more of material there. So yeah, we're going to be hitting a few highlights along the way today, and then in 2 weeks when we come back again. So we're just touching on some highlights, but each one of my slides down in the lower right-hand corner, you'll see page 4. That's where you can go to the materials and kind of follow along. But I'll be bouncing around a bit because I've restructured and reorganized it for this kind of a quick presentation, to give you a quick overview of where I'm coming from and the things discoveries I've made. So I was always taught that the primary duty that we have was laying out and retracing boundaries. Those are the two things the surveyors do. You can find it in the textbooks. You know, you're either the original surveyor laying out a boundary for the very first time, marking it on the ground, setting those monuments as an original surveyor, or you're retracing the footsteps of a surveyor who's already laid it out and marked it out before you. So that's our primary function. And then at some point we finish our survey and we have to document it. We have to document our findings, and we document the location of the boundaries and what the record dimensions were and what we've measured those dimensions to be, because none of the dimensions ever work, right? And that's just the reality of it. And then we perpetuate that evidence into the record. Some states do that very well. Some states do it not at all. And there's a real failure in our profession on those states that do not perpetuate the evidence, the survey evidence, for the future. When we're talking about documenting and perpetuating evidence, we're not talking about for the benefit of the client, the landowner, the attorney, or the title company. We're really talking about the future generation of surveyors who are following after us. We're documenting, and that evidence we need to put that evidence out there in a public repository of some sort, so the next future generation of surveyors can come in and find that survey, can see what it is we did, and can then follow our footsteps and perpetuate those same mistakes we make, because that's what retracement surveyors do. Is you discover a mistake and we're required by law to repeat the same mistake, so we end up in the same wrong location. And that gives you stability in land boundaries. That's retracing, that's following the footsteps, is to do it wrong the second time too, to make the same mistakes, mismeasurements and whatnot. And we have a real issue with our technological advancements, where we're now using the technology that gives us a greater degree of precision that never before existed in our profession. We're trying to follow footsteps with this greater precision and expecting the footsteps of the past to fall in our circle of error. And we've got to change that thinking and you know, twist it around 180 so that we can really understand that we're trying to perpetuate evidence into the future that meets our standard of care today, while at the same time recognizing the inaccuracies of the past. And accepting those inaccuracies is just reality. It's just the way it is.
Hey, John.
So
John,
I was taught, you know, that primarily box 1 and 2, that was it. Once you documented that's your findings in your survey, you document all those mistakes and problems and discrepancies and conflicts in evidence and deed conflicts or whatever they are. You document them very well, and we are taught to be very good at that. We excel at it. But then I was taught that that's the end of the surveyor job right there. The rest of it from there on out, that's all up to the attorney and the client, and he's going to have to go get somebody to fix this for him and somehow work it out.
Hey, John.
Yes.
I don't think your PowerPoint is showing. You said you're sharing your PowerPoint.
Well, that isn't going to work then.
Yeah,
How about if I do a share screen?
I was trying to grab you real quick. Yeah, sorry.
Try this.
There we go. It's coming up now. There you go. 1 and 2. Perfect. All right.
That'll help.
There we go. Thank you, sir.
So, yeah. So we end up we're really well instructed and taught how to document this information, and then that's the end of the day. But in reality, what we find out though is that there's a whole nother level of things that has to happen or in order for that client to have a product that they can rely upon, use, perpetuate their boundaries with. And somebody's got to stick around and fix it. Somebody's got to be able to repair the problems that are being disclosed by the surveyors. And that's this idea of assisting landowners to resolve the discrepancies. And it took me a while to really figure out what that really meant and what kind of a role can I play as a surveyor to assist landowners to fix the problems that I've discovered. And rather than documenting the problem, assist them in fixing the problem so that I can then work to document the solution to the problem rather than the problem itself, and give them a final product that is actually something that's usable. There's so many times we find in the survey record where there's 2 or 3 surveys have been done and they've all show the same problem. Nobody's ever dealing with it or fixing it. Somebody ultimately has to do that. And typically I was taught that, yeah, you send them to the attorney, he'll go litigate it in court, and then let the court decide. The judge will decide where the boundary is. Well, there's only one profession that's licensed to determine boundary locations in the United States of America, and that's us, the profession of the licensed land surveyor. The judge isn't a licensed land surveyor. He's not licensed to determine a boundary location, but he's licensed to determine how to resolve the discrepancy or how to resolve a dispute between 2 parties. That's what he does. And he does it by applying the same rules, same procedures, and same principles that we do. But the fourth thing we can do, which I think is often overlooked, is acting as a consultant for the attorneys, working with the attorneys to help fix this stuff, or as an expert witness if it does get litigated in court. So we can always go that route as well. And then once the gavel comes down that says, okay, problem resolved, the surveyor still needs to be in the room to document the solution to that problem. I've seen way too many court judgments come down that I was in the courtroom and read the judgment and I can't figure out what the judge is saying the answer is. And yet I was there to witness the solution. And so I really found through that process that the attorneys are great at litigating the issues. Once you can get them to understand them, it helps. But they have an equal amount of difficulty in documenting the solution that was derived in court. And it helps to have a surveyor. I think we're a necessary function in that process to be able to assist that attorney in documenting that final judgment, getting the final judgment filed, and getting it filed over in the title records where it ultimately needs to be, not just in the court records. We all love Chief Justice Cooley. I don't know of a surveyor around that hasn't heard of Chief Justice Cooley, Supreme Court Justice of Michigan. In 1878, had Supreme Court a case come before him, the Deal versus Zanger case, which is an ultimate read for every land surveyor. As I've gone around the country, every state that I go to, it's one of the things I research is to see if they have a quotation out of Deals versus Zanger. And the vast majority of states, courts have quoted Chief Justice Cooley out of this 1878 case, because when this case came up before him, he was considered an early American jurist, and he was just had a keen sense of understanding the big picture of what's really going on here. And he wrote this. He was asked actually in 1881 to make a presentation to the second annual conference of the Surveyors and Engineers Association in Michigan, and he was their keynote speaker at their conference. And in 1881, then he gave this keynote address, which has been now published and republished in our survey textbooks. You can currently find it in the Appendix C of the Evidence and Procedures book. And it's in multiple textbooks, surveying textbooks from here all the way to the back to the beginning, back to the 1880s. And it was entitled The Judicial Function of Surveyors. The point of his article was here's what the courts expect land surveyors to do. And it's timeless, a timeless article. And he really unfolds a lot of stuff in there. And I tell you, you read it and reread it and study it and then reread it again. And there's always some new gem in there that you just, it's like you miss these little key points that he makes. One of the statements he made here was the surveyor, on the other hand, must inquire to all the facts, giving due prominence to the acts of parties concerned, always keeping in mind that the courts and juries may be required to follow after the surveyor over the same ground, and that it's exceedingly desirable that he govern his action by the same lights and same rules that govern theirs. What he's saying here is that when the judge decides where a boundary is, he's following after us, applying the same rules and the same guidelines and the same laws that we are expected to apply when we do our work. There's really no difference between what a surveyor does out there on the ground and what we do in gathering evidence, reviewing evidence, analyzing evidence. There's no real distinctive difference between that and what a courtroom, what goes on in the courtroom for the presentation of evidence and that such. I'll get into that a little bit more here in a little bit. When it comes down to what goes on in court and a party, everybody has the right to go to court. If they've got a dispute with a neighbor, they've got a conflict, they have the open doors provision in the courts. It's a constitutional right that everybody has this open and free access, not free, it's certainly open and expensive access to the courts to resolve any problems that they have. But in this Missouri Constitution, I found this quotation. Well, it was actually a quotation out of a case in Missouri. They quoted the U.S. Constitution, the Missouri Constitution, and then they say parties to disputes have a right to waive their day in court and to equitably compromise and settle their differences as it is the policy of law to encourage freedom of contract and peaceful settlement of disputes. The landowners are the ones who own the property. They have all the authority they need to fix any problem that comes up between them. And when they have a boundary problem, the only two people who can fix it are the two adjoining landowners. When a lawsuit is filed over a boundary, it immediately erects a wall between those two owners and prevents them from speaking to one another, when in fact they're the only two who can actually deal with the problem and can fix it.
Schroeder's got his hand up there if he wants to.
Sure.
Go for it, Mike.
Yeah,
Michael?
John, you're very clairvoyant, and there's so much of this that our younger generation has their head in the box. And, it crosses, I hope I don't rabbit trail you here too much, but it crosses into pincushions. And when I was BLM cadastral chief, every time I would get a survey that came to me for approval and they would reject a corner, I'd say, prove it to me. I mean, it's all about having harmony and settled boundaries.
Yes.
And if somebody, a young guy had their head in the machine, says, well, my measurement's good and this private corner is off. I said, well, throw it in least squares adjustment, weighted least squares adjustments. This is a 1950 survey. So give him a half a foot on his chain and give him, 30 seconds on his angles and see where you're at. You can't reject the stuff. I think we're our own worst enemy in a lot of this stuff is that surveyor. Yeah, if you find a really big conflict or you found fraud or improper survey, it's a different deal. But there's a lot more that we can do, and I'll just shut up because you're probably all headed for it on your presentation here. But we have the power. That's what I just heard from you. We have the power to maintain harmony, and settle boundaries between owners is a good thing. I mean, I don't think Thomas Jefferson, when he set up the whole thing, thought that there was going to be chaos for hundreds of years.
Right.
And Cooley had that unique insight to that. So that,
yeah. And I would even go so far as to say it's not about necessarily the power or the authority. I would say it's more of we are duty bound by law
I was going to say
to do that, to understand the difference between mathematics and boundary law and legal principles that and the way that boundaries are established and such. And we'll talk a lot about that here in a minute. One of the things that I had, I've taught land boundary law for this is be my 31st year at Salt Lake Community College in a 2-year associate degree program, two classes of Boundary Law 1 or Boundary Law 2 that I teach there. And when I went to school, I read Cooley and was taught out of Cooley, and that's one of the first things that I throw out there for the students to read is Cooley's article, because it is so timeless and he had such a great insight. And I tell you, I've read and reread and taught from that thing for years before I ever really read this part of what he said, where he says, it is always possible when corners are extinct, the surveyor may usefully act as a mediator between parties, assist in preventing legal controversies by settling doubtful lines. When I stack that statement up with what I was taught to do, which was to document the problem and send them to the attorney, how does that prevent legal controversy? It doesn't. It promotes legal controversy instead. And he's saying, no, you can usefully act as a mediator. I was in mediation sessions. One of the first mediation sessions I was ever invited to, I didn't even understand what was going on. And after I left, seeing how it was successful and the parties settled their lawsuit at the end of the day, on the way home was wondering what the heck just happened? What was that all about? Started doing some research. What is mediation and what is this all about? And found out, yeah, it's not a real big deal. It requires special training, especially from a surveyor's perspective, because the last thing I care about is what people think about where their boundary is. That's my job to determine it. But when there's a problem that needs mediation, I was able to at least get some training to learn some skills and techniques I could use to encourage the landowners to settle this controversy without calling attorneys, because there's no reason to call the attorneys, because the whole goal is to prevent the legal controversy, not kick the sleeping dog in the hind end. He goes on in his article, he says, and this one really stumped me. This is one of those that it took me a while to figure out what he's talking about and to get really into the meat of the matter here and to find out how I could actually do this. Of course, nothing has been said that can require a surveyor to conceal his own judgment or report the facts one way, believes them to be another. He has no right to mislead. He may rightfully express his opinion that an original monument is at one place, when at the same time he is satisfied that acquiescence has fixed the rights of the parties as if it were in another. Monuments, original monuments, control over course and distance. Mantra, 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 my head explodes. It's like, how can you be comfortable saying, yeah, there's the original monument right there. You can kick the stone, yeah, that's it. But no, your boundary's over here because of this and this and this, and you did, and the actions of parties, and taking those actions of parties into consideration. That was all that part of the unwritten rights stuff that's in the textbook about. That's the stuff that you have to know about, but you can't do because only a court can do that. Well, that's not what Cooley is saying. He's saying I, surveyor, need to be able to be satisfied when acquiescence fixes the rights of the boundary location in one place, even if it contradicts an original monument. And that doesn't square with what I was taught. He also goes on and says Yeah, this is some of his insight to the surveying profession. When a man has training of exact sciences where everything problems in purview is supposed to be susceptible of accurate solution, he is likely to not be a little impatient when he is told that under some circumstances, he must recognize inaccuracies, govern his action by facts which lead him away from the results which he theoretically ought to reach, which is exactly what is the point Michael was making. You've got to recognize that these measurements were inaccurate. And they were more inaccurate than we have. And my goodness, every now and then a surveyor actually made a blunder. Well, sometimes blunders, it's too late to fix them. It's too late to deal with inaccuracies. The deed has been done. So we need to really step back and learn what is the perspective that the courts have on surveyors and what we're supposed to be doing, their expectations. I started researching some anything old that I can find to find out what did surveyors used to do, and found this one. This is out of it in Texas, the instructions, regulations by which surveys will be governed in the location of vacant lands in Texas. And it was instructions to the surveyors. The 15th article said it will be the duty of the surveyor before commencing any survey to see that adjoining proprietors are notified in order to promote general harmony of the neighborhood. Why are we doing that? And now we might look at it and say, well, that's, yeah, you have to put up the door knockers on people's homes and hope that they're not there when you do that, so that you can get your right of entry permits. But no, that's not what he's talking about here. Is no, promote the general harmony of the neighborhood. Let the people know you're there to do a survey. Introduce yourself. Do some reconnaissance work, which I think is probably one of the biggest failures of our profession right now, is the licensed land surveyor sitting behind a desk in the office who's doing the reconnaissance work and walking the job site and looking at the evidence and talking to the landowners and gathering the all-important verbal testimony of what they know about their boundaries before we start the survey. Article 16 says, where a difficulty arises concerning the right of location of a particular place, it'll be the duty of the surveyor to use all reasonable means in his power to induce the parties to settle their differences in an amicable manner. When did we stop doing that? This is exactly what Cooley is telling us. This is 1827. Cooley's in 1881, telling us the exact same thing. Stop what you're doing. There's a duty of the surveyor to, to try and induce these parties to settle the differences, fix the problems that we discover. Don't just pass them on and expect somebody else to do it. Then it goes on in Article 16 says, but if the dispute is about a particular line and an amicable adjustment cannot take place, it'll be the duty of the surveyor to desist from any attempt to survey until the dispute is settled. That was a real epiphany moment for me when I discovered that, because what that allowed me to do is say, okay, I have a clause in my contract that says upon discovery of an uncertainty, ambiguity, or dispute, I will stop work. And I will inform the client of the discovery. I will work with the client to resolve the discrepancy, to do additional research, whatever it takes, do addendums, whatever it takes to do the additional work to figure out what we need to do to fix this thing. Then once it's the issue has been resolved to my satisfaction, I will finish the survey at the agreed upon price. And it gives me the ability to now expand the scope of work to include all the hard stuff, the difficult stuff, and whatever it takes to resolve the problem and solve the discrepancy, the conflict in the evidence. Might be, a little bit more research, might be more field work, might be talking to some prior owners. I don't know what it's going to take. Every job's different. We all know that. But it allows me to make those additional researches and discoveries, gather that additional evidence, figure out the hard stuff, apply the rules of law that are designed to fix the problem that's at hand, so that we can make our determination of where the boundary's at. Once I know where the boundary is, well, now I can finish the survey at the agreed upon price. And I can do a fixed price survey and still make money on the hard stuff instead of this attitude of having it as a loss leader. Oh, that was an expensive, lesson. No, those expensive lessons are the ones we should be making money on, and people are more willing to pay you to do because they're more difficult. They're outside of the norm. Skeleton on Boundaries, one of the best books you can ever get on boundary law. There is no better out there. It's published in 1930. It never underwent any changes until around 1972, 73, 74, something like that. A couple of gentlemen got a hold of the publishing rights on it, and they went through the book. Skelton was an engineer, so he said the engineer needs to do this, engineer should do this, engineer should do that, when it should have been the surveyor. So they did a blanket search of the word engineer in the book and changed engineer to surveyor. And then on the footnotes, he has footnotes to all the court cases that say what he's talking about in the text. And they updated the footnotes to add more cases that still say the exact same thing today. Aside from those two changes, they didn't change anything in the entire book. It's in a hardbound book. It's a blue kind of an edition. And I've only seen one, and I've got a copy of it, but I've never, I don't know, there can't be many of them out there. So I'd be curious to see if anybody else has one, the updated second edition of Skelton. But other than that, the boundary principles he's talking about in his book are timeless. They are the law. They are boundary law. And the boundary law has not, there's nuances and more and little changes and stuff that happen over time. Different jurisdictions kind of take a different path and maybe use a little bit different verbiage, talking about the same principle. But the basic principles are always there. Every state I go into, I research their boundary laws, and yeah, I find court cases that fit with the same principles in the same manners, in slightly different manners. Let's see, when it's definitely proved that a fence or wall of marking a given line is not in harmony with the lines of other improvements, which check with their own deed calls. So you got deed says this, and you've got fences and occupation lines that are in harmony with each other, but not in harmony with the deeds. Deed says one thing, occupation says another. The matter is primarily one of law, hinging on the question of establishment. The surveyor should then make a situation survey to show the lines of the original survey, contradict how they contradict the line in question, and where possible, explain the discrepancy. Now, this situation survey, I would say, okay, call it an exhibit or a site map, or some kind of a sketch. It's not a final survey, because you stop work on the discovery. In all cases, the extent of the conflict should be indicated, but no recommendation as to which line as the boundary should be made. When you're giving information and evidence of your findings to the client, you don't give them the solutions. You give them an understanding of the extent of the problem. And then it's the duty of the two landowners to come up with the viable solution for their problem, their common problem. They're the ones with the authority to fix it. And as a surveyor, there are certain laws that I can apply, and we do it all the time to resolve conflicts in evidence, and we'll talk about some of those. But there are certain things that the surveyor doesn't have to do, that the landowners need to do to make sure that they're comfortable with whatever they choose to settle these issues. And it says in all cases, the extent of the conflict, let's see, I read that one. To prepare such a plat intelligibly, the surveyor must have a knowledge of the legal principles of establishment. These establishment principles that he talks about in his book, he's got an entire chapter on the establishment, boundary establishment. And that was another epiphany for me, because I always looked at boundaries as being something that's out there, a mathematical representation that's put into physical evidence on the ground. So we've got physical evidence to try and chase this invisible boundary. Where in fact, I've found that by definition, A boundary is a physical object. It's a physical, it has physical properties. It's not just an invisible line defined by some mathematical principles. So surveyors are often the first to define the conflict, to find or discover a conflict between established line and its corresponding deed line. Where boundaries are unsettled, such discoveries are likely to start a dispute. And I cannot tell you how many boundary disputes I have had to deal with where the surveyors basically have just given up, or had two conflicting surveys. We can't leave the client or the general public in that kind of a situation where there's two possibilities, two possible answers. They have no knowledge, skills, experience, or expertise to resolve those issues. I broke down, finally, just trying to wrap my brain around some of these concepts over the years. I've finally figured out that every boundary line goes through two steps. This two-step process. The first step is to create the line. That's title law. Requires a conveyance of somebody owns a 20-acre field, they sell the west 10 acres of their field. So they're conveying a portion of their property, and that conveyance creates a boundary. That boundary may be surveyed, may be marked, may be monumented, maybe not. But there has to be a conveyance to create it. And that's done under title law and conveyancing law, which are statutory provisions, not common law provisions. You create the boundary line, then at some point, somebody's got to establish a location of that boundary on the ground and fix its position based upon some physical objects so that people know where it is. Otherwise, you would never know where any of these boundaries are. They'd just be some empirical mathematical solution. So to establish location of a boundary on the ground, boundaries are established physically on the ground by objects, physical evidence, monuments. And it's that two-step process. You create it with title law, and then you establish its location under boundary law. Boundary law will tell you where the boundary is. Title law tells you what the nature of the property, the ownership is, the quality of the ownership, who owns the property, things like that. Those are all title law questions that are used to create the property boundary and to separate what was one estate into two separate estates with a little boundary line separating the two estates from one to another by the creation of that boundary. With different ownership on each side. So boundaries have to be created, which is a contractual arrangement under title law that will take this boundary and will create under this contract, basic contract requirements, you'll have an offer to sell a portion of their field, an acceptance of that offer to buy that 10 acres, the assent, meeting of the minds, the contractual arrangement of their meeting of the minds, and then sufficient cause or consideration. The execution of the document, and once the deed is completed, then now you have a boundary. It doesn't even have to be recorded. You have a boundary once this document happens, once this those 5 requirements are entered into. Every boundary that has ever been created has been done so in writing by fulfilling these 5 requirements. That creates the boundary. Now you want to know where it is? Well, that's boundary law. And you have to go through the intent, the landowner, their intent to establish a boundary, and assertive action marking it, representation and reliance upon the line as a boundary. Those 4 things have to happen in order for a boundary line to become established or fixed in location. That takes us to these boundary establishment doctrines: parole agreement, implied agreement, equitable estoppel, practical location, and in some degree, and I hate to even put it on the list, adverse possession. Adverse possession really is not a boundary law doctrine. It's a title doctrine. Based in title law. It's a provision that will settle the ownership of an entire parcel of land, as opposed to a boundary doctrine that just says, we don't know where the boundary line is. Where is the boundary? That takes the evidence that under these other four doctrines. And really, those are the only four doctrines that all boundary law is based on: parole agreement, implied agreement, equitable estoppel, and practical location. All boundaries are established based on one of those four, at least one of those four. And then we come to this idea or question of where is or what is a boundary? And I think because we're in the profession, we don't even really think much about it. But when I really sat down and read, this is out of a definition of a 1914 Bovier's dictionary, Bovier's Law Dictionary, and then there's a Barill's 1870 dictionary. That's where these two definitions come from. But the definition is every separation, natural or artificial, which marks the confines or line of division of two contiguous estates. Okay, it's marked by physical monuments. It's a separation that has a monumented line. It's not some invisible line defined by some mathematical properties. And a boundary, they're all controlled by these, stone wall, fences, and then sometimes a boundary is created without having been surveyed, and so there's no markings, there's no monuments to mark its location. If that's the situation, that nobody's ever surveyed it yet, then you have what this second definition has in it. About halfway down, it says, sometimes an imaginary line drawn from one principal terminus to another, indicated along its course by prominent natural and artificial features standing or erected upon intervals. Sometimes all of these in combination. But it can be an imaginary line because nobody's marked it out on the ground yet. If you want to know where your boundary is, get a survey, mark it on the ground, erect your monuments. I was always taught, as I'm sure we all were, of what meets and bounds means, right? Meets means what? Measurements. Bounds means the property you're bounded up against, the bounding calls. So you got the measurements and the bounding calls. And if you look in the boundary control legal principles, evidence procedures books, they go into a big, long discussion in one chapter about where the terms meets and bounds came from. And in reality, they come from Roman law. And then, because I always thought, when I was doing the research on this one, I was trying to go back and use these maxims of jurisprudence are called. I was researching back in the cases, trying to find out where these maxims came from, and discovered that these maxims come from Roman law. And then I had one of those epiphanies where I was always expected, or at least taught, that our laws came as a body of law from England, and so we have English common law as our foundation. Well, no, we had a revolution in 1776 and upset the apple cart, and we are under American land law, and our American land law came from Rome through the three branches of government and all that kind of stuff. And so our American land law is Roman law. And when you look at in Roman law, I've got a book that's really cool book on the Roman surveyors, big thick book that has all sorts of information about surveying and the profession of surveying in Rome. And the two terms, meets and bounds, were actually meta and bunda. Meta is the chariot race course. The meta is this turning point in the chariots, and would turn around the meta, which are these somewhat phallic symbols here in the end of the race course. That's the turning point or the end point of the boundary, the meta. And then the bunda is actually this platform that is constructed to connect the meta together. And the bunda is like the VIP seats in the Roman race chariot races. So the meta was the turning point, the end point of the bunda, and the bunda is the boundary, the physical objects of the boundary. So you're talking about monuments and monuments, not monuments and measurements. They were both monuments. The Roman surveyors were instructed to go out and survey the field by meta and bunda. by marking the corners and marking the points along the line, and physically monumenting the boundary as well as the corners. So that kind of changed my whole perspective on the whole idea with measurements having anything to do with boundaries and boundary law. There's such a so low on the totem pole that all of our rules of evidence and everything we've been taught puts bearings and distances way down there at the bottom, just above area calculations. And because monuments are physical objects. Well, every time we determine a boundary, we do 3 steps. First thing is gather evidence. We gather documentary evidence, demonstrative evidence, and testimonial evidence. The same 3 things that a courtroom will look at. Prior surveys and stuff, maps and all of the deeds and chains of title and all those documents that are in there, even letters to neighbors, emails between neighbors. They have all sorts of documents that are brought into a courtroom. There's the demonstrative evidence. That's the physical objects. The surveyor has to go into the courtroom to be able to testify that, yeah, there's a fence post here, there's a pipe here, there's a stone there, there's a ditch here, there's an occupation line here, and how they relate one to another, their relative locations. That's the demonstrative evidence, the physical objects that appear to mark a boundary. Then you've got the testimonial evidence, the parade of witnesses, the old farmer who comes in and says, yep, I know where that line's at, and tells the story to the judge that here's what I know about that boundary. And who do you think the court's going to look at and listen to? Some surveyor who's never there when it all happened, or a farmer who lived it? That's why testimonial evidence is so important. Once you've got the evidence, now we have to analyze the evidence and weigh the evidence and prioritize it. We have to determine what the facts of the case are. We prioritize the evidence, weigh it, we apply the rules of evidence. Every surveyor needs to Google rules of evidence in my state. And you will get a copy of these rules of evidence. You read through those rules of evidence and you will have a wealth of information. As you read through it, you'll say, yeah, we do this, and yeah, we do that, and we do this, and oh, that's why 20 years, and oh, that's why a 20-year-old survey. I need, if the surveyor is more than 20 years old, I need to call the surveyor and talk to. I can't call the surveyor, don't need to. But if it's less than 20 years old, I'm required by law to contact the other surveyor and gather testimony about the survey, because it's in the rules of evidence. And those are the same rules that the judge and jury will follow. And that's the rules that the Cooley is talking about. Us following those rules, because the judge and jury will follow with the same rules after us. Rules of evidence, rules of civil procedure is another one. How to interview a landowner, how to ask questions, leading questions, and that kind of such. Once you've determined what the facts are, now you have to apply the rule of law to determine where the boundaries are, because facts will never tell you where a boundary is. You have to have a legal principle that's designed to fit a certain fact situation. You apply the legal principle, and the result is determining what tells you where the boundary is. And the boundary is there not because I, Joe Surveyor, have decided that's where it's at. The boundary is there because the law tells me that's where it's at. Application of that rule of law, that legal principle, is what defines where the boundary goes and where I set my marker, where I formulate or derive my opinion, is in that application of the rule of law. You got to have the appropriate rule of law. For every conflict and every problem that's out there, there's a rule of law that's designed to resolve it. We just have to gather the evidence to determine whether or not they have met the requirements of that rule of law. Apply the rule of law in accordance with the rules of civil procedure, and express your opinion derived from the evidence, facts, and law. And that's what we do ultimately on every survey we do. I've got one example here that I just kind of would like to show that will give us an idea of the difference here. And it's a simple one that we do day in and day out. You got current deeds for a piece of property. and they indicate the parcel was divided into 2 separate tracts. Each tract is 50 feet of frontage. There's no survey that's been conducted to mark the line between them. So there's no evidence at all. No, there's no physical evidence, no occupation, no monuments on the ground, but you find the 2 original markers and you measure between them, they're 110 feet apart. Record says 100. Where do you put the lot line? Where do you put your marker? Hopefully somebody out there will
Right? Anyone?
jump in.
Anyone?
Up here in Alberta, we would do it by proportion, so halfway
Yeah, you
between.
do it by proportion of measurement. So it'd be 55-55, right?
Roger that.
Yeah. And why do we do that? Because that's what surveyors do? No, it's because that's what the law requires. The law says that a simultaneous conveyance imparts equal rights to both landowners in all excess and deficiency. And therefore, you split it down the middle, and that's where it goes. That's the rule of law. And the reason you put your point there is because the law says to. Rule of apportionment says, this is out of Corpus Juris, CJ. That's a set of encyclopedias. There's CJ and there's CJS. This is Corpus Juris Secundum. They're legal encyclopedias. They're like the Encyclopedia Britannica, where you looked up A for astronaut when you're a kid. Yeah, you go to a law library and they've got these legal encyclopedias. You look under B for boundaries, or D for deeds, or E for easements, and there's hundreds of pages of how to determine easements and how to determine boundary locations and how to do all the stuff we do, because it's the law, and you find it in legal encyclopedias, hundreds of pages of it. So this is volume 9 of the Corpus Juris in page 295. It says, where a tract of land is subdivided, so is subsequently found to contain more or less of the aggregate amount called for, that the proper course is to apportion the excess and deficiency among the several tracts. Yeah, rule of apportionment. We all know that. We do it all the time, right? We don't hardly even think about it. But that's because we know that law and we're comfortable applying that rule of law. And that law tells us where the boundary is. Without that law, we got too many options. You got at least 3 positions that you could put that point in, and hopefully you'd hit one of the 3. Now change the facts a little bit. Current deeds was originally one parcel divided into 2 tracts. Each tract says it's got 50 feet of frontage, but you have a tract that came first. Tract A came in 69. Tract B is deeded in 1992. The west 50 feet and the east 50 feet. Where do you put your monument? Gets a little more complex, right? But senior gets what senior has. And what does a junior get? Does a junior get 50 feet, or does junior get the remainder? Plus or minus. The principle of law is that the junior is always plus or minus. He will win sometimes and he'll lose sometimes. And that's how the court maintains its equity. He's got an equal chance of winning or losing. And so junior is always more or less. Doesn't have to, even if it says 50 feet, oh my God, do we have a gap? Do we have a 10-foot gap between these 2 pieces of property? No, because a gap is a problem. There are rules of law designed to prevent that problem and to solve that problem. So if we're creating a problem by our interpretation that, it's got to be 50-50 and there's a 10-foot gap, we need to rethink our solution. Is there a 10-foot gap there? And then it falls back to these rules of logic, common law principles, that it's not reasonable for somebody who owned 100 feet, who sold 100 feet, to have 10 feet left over, to have intended to retain ownership of 10 feet. Doesn't make any sense. Doctrine of strips and gores in Texas. Tennessee has a doctrine. They're probably the one that spelled out the best, I think, was the Tennessee one. There's also this quote here out of West Virginia case. Generally, it will not be presumed that a party granting lands intends to retain a long, narrow strip next to one of his lines. But if the courses and distances approximate closely to a line or corner, of the tract owned by the grantor, especially if the description in the deed corresponds exactly or substantially with the description in the title papers under which the land is held, it will be presumed that the lines mentioned are intended to reach the corners and run with the lines of the tract. Simple principle of law that makes entirely logical sense. All we have to do is know it, understand it, and apply it. And most of us do when we say, yeah, junior's plus or minus. That's the application of this rule of law. And it's a simple foundational fundamental rule of law that is the mirror for sequential conveyances. Simultaneous conveyance is rule of apportionment. Sequential conveyance, this rule of law applies, where the junior gets plus or minus, junior and senior rights. There's a interesting court case I ran across it, and I was doing a presentation in Indiana one year. It was a fairly new case when I brought it up in this presentation. And it's a case where there's a quarter of a quarter section, 1320 by 1320. Right, like any of them are, right? Parent property is the southwest quarter containing 40 acres. 1913, they convey the west 21 acres. In 1922, the conveyance is the east 19 acres more or less, beginning at the southeast corner, running west 627, north 1320. How many corners are there? How many boundaries are there between Cook and Collins? There should only be one boundary between two adjoining landowners. The question is where? And these rules of law tell us where. Boundary law tells you where. It answers the where question. Surveyor took those descriptions, knowing this evidence, and said, well, okay, 1320, 21 acres equals 693 feet. So measure 693 feet, set a point. This one says start over here and go 627 feet. And that's in the more precise position of the description rather than the general description, which is the east 19 acres more or less. So the specific controls over the general, which is logical, but there are exceptions to all these rules, right? Especially when you've got an overriding common law of junior senior rights, where junior is more or less, and your deed actually says more or less. So he does his survey and shows that, well, there's a 40.5 acres, it's not really 40, and there's a 13-foot gap between Collins and Cook. So here's a surveyor created problem, right? And his failure was to apply the appropriate rule of law. The rule of law that says junior, senior, junior gets more or less. And yeah, it should have a boundary at 693. Should have been pretty straightforward. But because you've got a surveyor created problem here now, that surveyor documents that problem, hands it to the client, who gives it to an attorney who doesn't understand the problem, who takes it to court and hands it to a judge who doesn't understand the problem. They look at it and say, okay, the problem is there's 13 feet of property here that we don't know who owns it. Is there a 13-foot strip of property that we don't know who owns it? No. No, there's no 13-foot strip of land, especially when, you know, looking at that last principle, that last common law principle, especially when 693 and 627 equals 1320. And the 627 goes west 32, 627, it goes north 1320. I wonder how much of a gap he's got up there, or overlap because of his shortage. It gets to the point of ridiculous. But here's a surveyor created problem now that goes before the court. And what we're looking at are the facts of the case. Cook owns 21 acres, Collins owns 19 acres, and there's a 13-foot gap between Cook and Collins, and it's a title problem, not a boundary location and a boundary law problem. It's a title problem we need to have proof of title of this 13-foot gap. Court looks at it and says, well, Cook, you got your 21. Well, Collins, you got your 19. Go home. We don't have a third party here that's claiming ownership of the 13-foot gap. And they send them home with the same problem. This is an appellate court ruling. So they've already gone through it, gotten a survey, now had to go to court to try and resolve this problem, went to trial, then appealed that to the Supreme Court of Indiana, or the appellate court in Indiana Court of Appeals, and the Court of Appeals said, yeah, we don't, you only got two parties here, not three. Go home. You all got what you got. You don't have anything to complain about. So they end up, after spending probably, how much would you guess? Well, in California, I could hardly guess, but most places in the country, probably 80 grand a piece, maybe more. And they're told to go home, and they go home with the exact same problem that the surveyor told them they had. All they need to do is get another surveyor to mark out, to do a survey and say, no, this is 19 more or less. And here's the rule of law that applies that says where it is. But surveyors, we need to know and understand these rules of law, when they're applied and when they're not, and how to deal with those rules. Because these rules are designed to solve a problem, not create one. And if you're applying some rule of law and you end up with a problem as a result of it, you got the wrong rule. There's another rule of law that is specifically designed to fix the problem.
And this was in the great state of Gary, Kent. That's what's even
Yeah,
crazier.
right.
This is what's even crazier, that it happened in Indiana.
Yeah, and I tell you, the quality of surveys in that state are pretty amazing.
Absolutely, that's what I'm saying. That's
seen.
amazing.
Yeah,
it's crazy.
But you get those outliers, I guess every profession's got to have those outliers. As long as I'm on the extreme end of one, on the extreme right side, I'm okay.
Yeah, no kidding.
Let's see. So one party's always owned 19, the other party always owned 21. Here's the trial court judge says, if I rule that way, somebody's going to have to file an action to quiet title on this gap of land going back, giving notice to all the heirs since 1920. Because see, they turned it into a title problem, not a boundary location problem. And a title problem, is a quiet title action against all the heirs clear back to 1922 when they sold the last piece. And you'd have to say, well, the heirs to the parent property still own this 13 feet, and go and get quitclaim deeds, or even to track that lineage for 1920, and we're 2006. Got 84 years of lineage to track. Who knows how many heirs there are? Could be hundreds of them. It's crazy. It makes it almost an untenable position to try and repair those things. Says, nobody's paid the taxes on the gap. Matter of fact, the assessor didn't even know the gap was there. Didn't even show it. Doesn't even have it as a parcel number. And yet the surveyor says there's a parcel there. Yeah. On the record before us, there's no definitive proof that either Cook or Collins have established ownership of the gap. Gaps are not parcels of land. Gaps are just a problem with the math. The numbers don't add up. That's all that is. It's a mathematical issue, and there's boundary laws that are designed to prevent them. Gaps and overlaps are impossible solutions, because there's always a rule of law that's designed to resolve what appears to be an overlap, or to resolve what appears to be a gap. The overlap is simple to resolve. You don't own it. You can't convey it twice, right? So the first conveyance, the senior wins, the junior who's overlapping loses. Unless other things happen too, because it's not always, all these rules of law are rebuttable presumptions of law. That's one thing we need to understand about the boundary law, and what makes it a little more complex is that boundary laws establish what are called rebuttable presumptions. The law will presume this is going to be the outcome. That's it. Unless you have enough evidence to overcome that presumption of law. And that kind of again goes back to what Michael was saying about the pincushion issue. You got to prove that that monument, you have enough evidence to overcome that monument and disprove its position. And not with math. Math will never prove the position of a monument. You have to have the evidence that says, okay, they didn't know it was there. They never relied upon it. It hasn't been used by any of the parties, because the presumptions are that it is there and that parties do know it's there. They have relied upon it. They set it there with the intent of marking their boundary. Those are all presumptions of law. You have to show, no, there's evidence to overcome that, and that is not the fact situation. Therefore, a different principle will apply. And you can ultimately reject a monument. But if you can't prove the monument's wrong, then it's right. So yeah, overlaps. Grantor doesn't have the right to create a boundary across somebody else's property. To create an overlap, he has no right. The second boundary cannot exist. There's no, the cloud on the title is maybe there because the title company wants to do the math, but technically, the law resolves the cloud on title even. The only time that becomes an issue is if somebody raises it and says, oh my God, we still have this problem. We have a title problem. Well, no, it's resolvable by the application of legal principles. So let's do some documentation, get some documentation in the record that acknowledges the problem and acknowledges the solution and solve that issue so that we don't have to worry about documenting it. There's a number of different ways, and we'll hopefully talk about that next couple of weeks. But overlaps, unresolved conflicts, that's all they are. It's conflicting evidence. Apply the rule of law that's designed to resolve the conflicting evidence, and you have your answer. Here's the boundary. Same thing with gaps. First deed created the boundaries. Second deed attempts to describe the boundary that the first deed created. There's an intentional creation of the second boundary creates a third parcel. No, third parcel is not a gap. If it's a third parcel, yeah, people can retain ownership of a piece of their land if they want to, and yeah, they can create 3 parcels. But chances are that that's not what's occurred. And especially when you look at the assessor's records and there's only 2 pieces of property, no, there's no third parcel of land. There's no third owner. And we need to just learn the rules of law, apply them, and conflict resolved. I think I'll even skip this one. This is one where
you're done.
Yeah,
about
that's probably
15.
a good place to stop for some questions, answers if you want.
Yeah, I was gonna say it's perfect. We got about 15 minutes or so. So anybody want to kind of open it up to some questions and comments? There was a couple of things in the chat. Nick said the deed math tells you where to start looking for the boundary / corner monument. That was a good one. That's his favorite line out of that one. Let's see.
Math tells you where to start looking for the boundary. Yeah, that is absolutely the case. It
Yeah.
gives you the search area. That's all.
Exactly. Shorter, go for it, Shorter.
Yeah, so I'll put a little bit different twist on this, but it's the same because it follows a sort of a rule dealing with right-of-ways. The right-of-way gets the full width. So I worked for DOT for 4 years as a regional land surveyor. And I tell you, we looked at the history of what went on. So in Alaska, a lot of our right-of-ways were unmonumented. You know, it was the physical road, there were public land order withdrawals and previous right-of-way chiefs that says, oh, we're going to get the full 300 feet to 0.00. Well, there've been all these surveyors that have been surveying along these highways for years with physical road, and they split it and they inscribe curves based on the degree of curve. And we're talking sometimes tenths of a feet or half a foot. And I had a really good mentor, Jim Sharp, and he did go out completely on his own. He got the solicitor for the state, involved, and says, are we going to go and create these gaps or create these overlaps and create chaos and non-harmony and blow all this up? Or we'll do that, hey, in good faith, those surveyors that came before, they did the best they could. If it's 150.4 feet from center line, we aren't going to create a gap and create a title issue. No, we'll take it, we'll acquiesce, we, the state, will acquiesce to that monumented boundary of all these properties and keep the harmony. If we have an overlap of a half a foot, we'll scrutinize, we'll review, and if it looked like the guy did, the surveyor, prior surveyors in good faith, we're going to show an overlap of the right of way. But Clark and Brown, everybody else, you go in there, you're going to proportion, you're going to give the full 60 feet or whatever width of the right of way to 000. I think it was really overlooked. And once you got that sense that, hey, let's keep the peace, let's keep the harmony here, the amount of chaos in court proceedings and everything else, and then you file a set of right-of-way plans. And so basically, if the state, was shorted a little bit on their right-of-way, the right-of-way plans was a statement of fact that, yes, we've accepted those prior surveys, and we have, just a little bit short of our full right-of-way width. Now, if it was something huge, that's a different story, case specific, but, we're our own worst enemy. That's what I'm hearing, John's like, there is not a conflict here. Let's get our head out of the mathematics. But that's a hard one, because I know on land surveying tests, you get the classic thing that you got some lost corners, you have a right of way, and you're going to give them their full width. Well, not necessarily. I mean, every case is different. But if you have this principle of respecting, prior surveys and the harmony of title and ownership, that's the missing clause. It's not mathematics. I mean, you have to look at all this stuff. So thanks a lot. I'll shut up.
Go for it, George. I love it.
Okay, going along with Michael and a comment I made earlier in the chat, we have the same obligation to our client and the adjoiners that adjoin his property. Whether they're not paying us, but our client is, but we have the same obligation to them as we do to our client. And that obligation doesn't end with the discovery of a problem. We have an obligation to help them get together with the adjoiner that's affected and figure out some kind of acceptable solution. And then we can go on and document that and get things cleaned up in title and file our survey and go on with things. Our obligation in this profession is to solve problems, not create them. And I will agree with you, John. It took me a while to figure that out. I was lucky I had some good mentors that pointed it out. I haven't done the scholarly effort that you have, but you know what? In the end, I think I got there.
Yeah, you get an A+, George.
Justice put in the chat, did I miss? Oh, the first one. So what will happen to the gap? Is it given to the junior parcel, or does it remain as a remainder of the parent property? And then he goes on.
Yeah, I'd answer that one just by saying that the first thing that we have to do is get over the idea that there is a gap.
Right.
If there's okay, you either have two pieces of property with one boundary, or you've got three pieces of property with three different owners and two boundaries.
Right.
So those are the only two options there. But if you have a third parcel, where's the deed that created that parcel? Where's the intent of the landowner to create a second boundary and the intent of the owner to retain ownership of a strip of land?
Right.
You have to have evidence of that intent to even have to create the second boundary. And that's, I think, where we start failing is recognizing that all boundaries are created by the intention of the landowner. And when they mark their boundary, they're intending to mark their boundary. And those are presumptions that are in the law that are requirements. You can't have a boundary that's created by accident. They're all intentionally created and created in writing. Statute of frauds, I didn't throw that slide in here, but the statute of frauds in every state requires that all conveyances of real estate be made in writing. So there has to be a written document that created that piece of property. If you have a person owning a parent parcel, he sells the west part, the east part, and he intentionally retained ownership of something in the middle, well, you'll see that in the assessor's plat. And it'll be, have a parcel number, and it'll have an acreage. It'll have a separate third owner on it, and they'll be paying the taxes on it. When you don't see that third parcel in the assessor's record, it's a pretty good indication that it doesn't exist. You're talking two pieces of property. Junior wins and loses. Junior is just more or less, and the excess and deficiency, not the gap or overlap, the excess or deficiency falls to the junior. Unless there's other rules of law that can kick in, other boundary laws that kick in, that can show that the boundary's been established in a different location for entirely different reasons. And that's where we really have a tendency to overlook. And that we'll get into in the next session.
Perfect. This one you have up on the screen right now, this would be looks like it could be an interesting one.
Yeah, this is if we got a minute, this is a quick one. The lot 17 and lot 18 are on an unrecorded subdivision plat. And so there's no subdivision plat in the record, but it shows a lot 17 and lot 18, and they have a copy of the unrecorded plat, of course. And the deed for lot 17 and 18 says that their lot 18 is 40 feet and the lot 17 is 41 feet. The plat, however, shows 42 feet on lot 18 and 41 on lot 17. So the plat shows a different dimension than the deed, the meets and bounds deed for lot 18 has. And so the deed saying it's 40 feet, the plat, if you go by the plat dimensions, there's only about a half a foot issue here between these two corners, which isn't much, but 255 isn't much either. In this case, they presented evidence that let's see, they left an unconveyed strip, unrecorded plat. Fence line was maintained for a short period near the center of the disputed strip for the convenient enclosure of a small child. Yeah, it was little gates, little fences you put up to keep your 2-year-old tot lot, a little tot lot thing. So yeah, they had a tot enclosure that was kind of close to being in that area somewhere, kind of there for a while. So that was the only evidence of any fence line. There was a hedgerow that was in the 2.5 foot space. And the court looked at it and they didn't know what to do with it. So they, when they get a case of first impression, they apply their own principles. And basically he says they relied upon their equitable powers and divided it equally between the two parties and sent them home. Somewhat analogous to splitting the baby, the Solomon principle it's called, where you just split the baby in half and sent the parties home saying, yeah, okay, we'll just split it down the middle, go home.
That's awesome.
Not worth fighting over, in the judge's opinion.
But yeah, that's a good one right there, just because, you bring in the unrecorded plat, right? And so that just adds a whole nother mix.
Oh yeah, and and unrecorded plat, and I don't know why they were holding the two original monuments on the two sides of the other, how they determined the 2.5 fell between those two lots.
Right. That's awesome.
But yeah, always wanting to grab a hold of one monument and say the other one is the one that's wrong.
Yeah. Well,
why isn't the one you're holding the wrong one?
Right.
Well, what John just said that I heard is really important, because, if the intent of the landowner was to subdivide this and create 2 lots, who's asserting title for this 2.55 feet? The heir, is he still alive? If he's still alive, you could get it. No, my intent was not to leave it. 2.5 foot gap that the unrecorded plat is at. You know, if he's dead and gone, his heirs or successors in title. Again, that's a pretty strong argument, but it should never go to court. I mean,
Yeah.
I
would
think
say I worked
John
a
is on the
case here just
track that
recently.
you can resolve this without splitting the baby.
Yeah, right. I worked on a case here just recently where there was a strip of land that was an access road that was a distribution of estates from the 1880s. And it created like 7 parcels to all the children in this family, each one getting a parcel. And the very last parcel at the end of the road said together with this strip of land for the road. So the road was actually owned by that last person on the end of the road, and all the other parcels were given the right to use the road, and they adjoined on that road. But this strip of land for the road itself, because it was a separate designation in the title, the assessor just showed it as a strip of land and never assessed it to anybody because it was for a road between them. And they didn't ever tax anybody for it. They didn't put a parcel number to it. It's just a hole in their map. And school district owns property now to the south of this road, wanted to use that road for ingress and egress. And so they wanted to, the parties on the north side said, no, that's our road. We own that road and you can't use it. Parties on the north side didn't own the road. And so I just said, I told the attorneys, well, matter of fact, I started doing the title research on it enough to track a couple of heirs that were still alive. I said, let's just go to these heirs, get a quitclaim deed. Even if we only own a portion of the road, at least we've got some claim of title to the road and we can use it. So that's what they did, was just did an end run and went and got a couple quitclaim deeds, and they ended up actually acquiring most of the interest in the road. Probably got about 85% of the heirs to sign off on the quitclaim deeds. And the party who was claiming that they owned it, well, they didn't, never had any interest in it. So yeah, there are strips of land that do exist, and they are title issues, and you do have to do title research and resolve the title issue with the title problem with the title solution. But don't take a boundary problem and turn it into a title problem. That really crosses the line and makes it almost impossible.
You hit on a good thing there, John, which is what Steve Parrish, he always preaches, the separation between good surveyors and great surveyors is research, right? And
yeah.
And
don't be afraid to have to do the research.
Absolutely.
If you have the proper clause in your contract that gives you that ability to stop work and solve these issues before completing the survey, that was one of the major things that I had to figure out when I started doing this work, was how do I get paid for the hard stuff?
Yeah. How
do I get paid for that unknown condition that crops up that says, oh my gosh, you're gonna blow your budget on this one. And no, this is the hard stuff, and we should be charging double the rates to solve the hard stuff. Increase your rates it requires greater skill, knowledge, experience, expertise, application of these obscure principles. And somebody's got to figure it out and do it. And we're the boundary profession. So
yeah. Justice has one more in the chat. When doing boundary analysis, how many previous case law do you need in order to confidently nail down your boundary? Goodness, I can't talk today.
Well, every boundary you ever stake is based on previous cases and case law, because most boundary law, the vast majority of boundary law is common law principles, case-made principles. And so everything you do on a boundary, every time you set a corner, it's there because the law says so. It's just that when we're trained and taught as surveyors through the surveyor textbooks, we're taught that they're survey principles. The evidence of procedures and boundary control and legal principles. No, they're not legal principles, they're the law. And they're the law that's been established over centuries. And that's what we're being taught. So most of us are confident in the law and are very comfortable with applying legal principles. But as you get a little more and more difficult types of problems, those solutions require more and more advanced education experience, and more case law. And I've had I guess, well, the way I get started with this was just sitting down in my living room at night with the laptop and just researching and reading court cases. And one court case leads to another, that leads to another, and you just learn and learn. You have to gain the perspective of the court, which is very simple-minded, really. From a technical brain surveyor side, the courts take a pretty simple approach in most of their solutions, and they're quite logical. It's a matter of just learning the techniques and the processes and learning to apply them comfortably.
Nice. Yeah. I know Justin's studying actually to take his PS, so he's probably got lots of good questions to coach. Tyler, go for it.
Hey, thanks. So I had a survey recently where I called for an adjoiner, gave him meets and bounds, and of course I find the corner and determine it to be short of the adjoiner. It's not in the adjoining line. So now I've got that 3-foot strip, and I'm looking at this, and I'm taking the same thing that you're teaching here, which is clearly I have a strip and core. The intent was to go to that adjoining line, and so I wanted to but on the other hand, I found a corner, so the principle of evidence, I found a original corner. It was not in the line intended to go to. So I was sort of not sure how to reconcile this. And my question is, how would I reflect on a map what would seem to be a violation of a key principle, which is go to the corner where it says to go, even though on my map I resolved it to go to the adjoining line? How do I communicate that to the guy behind me so that he doesn't assume that perhaps I've done something incorrect, or I've not
the simple answer I've come up with is you just show record and measured on your survey. The deed says go this far to get to this corner. Here's the evidence I found that I've used to determine where that boundary has been established on the ground using these establishment principles. You know where the boundary is. Hopefully it's where the survey marker is, we hope. Sometimes it's not. It's you go, and once you know where that boundary is, well, now you're going to show that's where the boundary is on my survey. I show one line on the survey. I don't show two lines. I don't show a dash line and a deed line and an occupation line, or all these different things that we make up to try and explain the different pieces of evidence you're looking at. There's one boundary between A and B. I determine where the boundary is, and there's where it is. And then I show the record and measured dimension to get to that boundary, and the record and measured dimension along that boundary. I don't bother rewriting the legal description because there's nothing wrong with the description. You leave the description alone. There's a doctrine that we'll talk about maybe next time called the doctrine of reformation that prevents you from rewriting the legal description. It is what it is, and you just report your findings, report the evidence that you found, and determine where your boundary is in accordance with the legal principles. And there is no strip of land, there's no gap, there's no third line. Those are all just made up concepts that we struggle with to try and show the conflicting evidence that we have, and usually it's just measurements. Measurements just don't control. Monuments control, and there's physical evidence on the ground that is where the boundary has been established in accordance with physical evidence, in accordance with the intent of the landowners, the expressed language of the intent in the deeds themselves. There's all sorts of evidence that we look at and different sources of those pieces of evidence, but they're resolvable. There's always a principle that resolves it, and it doesn't. The end result of every survey should be one boundary between two landowners. That's simple. If you find that the evidence is conflicting enough to where you want some special documentation, well, okay, do it. Put some more documentation in the record to resolve your the conflicting evidence, so that you're satisfied with the solution, and then document the solution. So yeah, here's the boundary as agreed upon between these two landowners. And by joint affidavit filed in this book and page if you can. Whatever it takes to document that solution, and then you can reference the solution. And then when you go to set your point on the ground, it's exactly where the landowner is expected to be, because you've involved them in the resolution process. And when you go to set it, they're already satisfied with your solution because it's their solution, not yours. It actually removes you from all the liability as well, because now you're the original surveyor marking a boundary in accordance with the landowner's instructions and resolving a dispute or an uncertainty, and the courts will uphold those boundary agreements every day in court all day long. The judges love it when the landowners would get together and solve a problem, because then the judge doesn't have to rule against 50% of his constituency.
Yeah, I would say the latter one that you just discussed probably matches what you were talking about, right, Tyler? Because that's what he was saying is he found the original corners, but the lines of occupation don't fit that original corner, basically, right? That's kind of what you're saying, Tyler.
Right, and I'm trying to, trying to understand how do you reflect that on a map so that the next guy is not like.
Yeah, to me, it's
Comes
more of a, found this evidence on this boundary, determined the boundary to be established based on this evidence. And now you've shown where you're bound, how you arrived at that decision. And you can do that in the form of a narrative. And then by your dimensions on the plat, showing record and measured dimensions, you can see the difference between the two. And who's surprised that the record and measured are different? Very few people are ever surprised about that. And show me a section that's got a half a mile between corners. Show me any kind of boundary that you can match to the 100th. It just doesn't happen.
Right. If you don't, do you have anybody to bounce those off of, Tyler? If not, you can send them my way. You can send it like your survey before you want to record it or something, send it our way. I can even throw it to John or whatever. But if you don't have, a network of friends or whatever to bounce that stuff off of, I'm more than willing to look at it too. So.
Oh yeah.
Yep.
I'm always available to take an email or answer an email or, throw me a copy of a map and ask me a question. I'll do my best to try and give you an answer, unless I'm completely swamped. It might take a day or two, but I try and get back to people who have reached out to me as quickly as I can.
Yeah, that's awesome. Anybody got anything else? Want to get so one thing we want to remember is this is an 8-hour conversation that that John does, and we're kind of condensing it down to really about 3 hours or so. So we'll
actually, it's 16 hours condensed to 3.
Right. Yeah. Part 1 and part 2. There you go. Yeah.
Part 1 was for the first 8. Yeah.
Yeah. So it's definitely abbreviated, but we'll keep that in mind. But you wanted from a homework standpoint, you wanted them to kind of review
I just wanted
the remaining part of the document. Yeah.
I just wanted to ask everybody if they just read through my materials and if you see something that makes your eyebrows go up, highlight it. Let's talk about it on the next session. I'd like to get some good interaction, because I find in these presentations that I make around the country that the best part of the whole thing is usually the last afternoon of the presentation, when people start getting real comfortable and start asking questions. Well, how do you do this and how and why? And so let's hopefully be able to do that. And I can bounce around in the next presentation a little more and be a little less structured with it.
Awesome. I love it. Yeah, and we're going to take next week off because it's Halloween. Everybody's going to be out partying with their kids. So we'll be back on Monday, November 7th. So if nobody's got anything else, have a good week, everybody. Thanks, John.
Thank you much.
I love it. Thanks, everybody.